later, the complainant went back for the remaining 2.2 million, but found it missing the car. In addition, indicated the CCTV footage at the school showed that the motor vehicle registration number KCR 595D, Salon, silver in color, with 3 occupants who were seen alighting and gaining entry into the complainant's motor vehicle and walking away with a brown envelope believed to be containing the money. And that on 6th of June 2024, the respondents were arrested at Kasarani Police Station public parking. The prosecution submitted that the first 4 respondents were police officers who had a unique subset of skills, and they can interfere with witnesses since they know how to locate suspects and witnesses. The gist of the prosecution submission was that although bail is a constitutional right, the same was not absolute. The deponent, Inspector Mondi, was cross-examined and informed the court that the arrested respondents will pursue the 5th and 6th respondents, and he was not aware whether the 1st to 4th respondents were on duty. Further indicated that the suspects were arrested on 6th of June, compelling reasons as to why the respondents cannot be released on bond with any investigations and will cooperate with the investigating officers. Mr. Mwambi, counsel also for the 1st to the 4th respondents, further submitted that the application was malicious and that under Article 25C of the Constitution, the right to a fair trial cannot be limited to any person, including the 1st to 4th respondents who are police officers. He further submitted that under Article 27 of the Constitution, the respondents should be treated equally like everyone else. In his submissions, he further stated that the 4 respondents, by having special skills, should not be treated differently and their rights be taken away. He relied on the case of Michael Rotich versus Republic and Betty Chemtai versus Republic, where the judges extensively discussed Article 49 of the Constitution. He further submitted that the court should not come to the aid of the police in conducting investigations and that they were out on a fishing expedition. Mr. Businge, for the 5th and 6th respondents, submitted that the state had not fulfilled the compelling test to have the suspect held for 14 days. It's not in dispute that bail is a constitutional right as provided for under Article 49(1)h of the Constitution. While accepting that the text of Article 49(1)f, the Constitution may in certain circumstances and contexts comprehend a situation where a person is presented before a court without being formally charged and is therefore informed of the reasons for his continued detention through the state's application. In the High Court, Criminal Revision number 203 of 2020, the case of Sudi Oscar Kipchumba versus Republic, through the National Cohesion and Integration Commission, the Honorable Justice Professor Joel Ngugi, then a High Court judge and now the Court of Appeal, held that for continued detention, the state must satisfy a double test. A, and I'll quote, the state must persuade the courts that it is acting in absolute good faith and the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. And B, the state must demonstrate that the continued detention of the individual without a charge is the least restrictive action it can take in balancing the quadruple interests present in a potential criminal trial. That is, the rights of the arrested individual, public interest, order and security, and the needs to preserve the integrity of the administration of justice and the interests of victims of crime where appropriate. End of quote. The question is whether the prosecution has been able to demonstrate compelling reasons to hold the respondents in custody for 14 days so that the investigating officer can complete investigations. The investigating officer, while being cross-examined, indicated that the respondents were arrested at Kasarani Police public parking yard, and that a report had been made by one Victor Peter Wino, an accountant at Rafin International School, via OB number 29/04/06/2024. And thereafter, all the respondents were arrested on 6th of June 2024. I observed the investigating officer being cross-examined by counsel for the first to the fourth respondents, and I hold that there was no malice on his part. The prosecution, through Mr. Gashok and Mr. Witi, submitted that the respondents, being police officers, had the ability to interfere with witnesses as they have a subset of skills of locating witnesses. Under the bail and bond policy guidelines of this court, the courts have a duty to balance the rights of a person and the interest of justice. The state has a duty to preserve public safety between the time of arrest and the trial, and to protect the integrity of the criminal justice system. Therefore, taking all the issues into consideration and the fact that the respondents have been in custody from 6th of June 2024 as per the investigating officer, I hereby allow the prosecution application. The respondents will be held for 4 days only from today. The first to fourth respondents will be held at Kayole Police Station, that is for 4 days. The fifth and sixth will be held at Ruai Police Station, also for 4 days. 4 days, it will take us to Friday. So the matter will be mentioned on 14th of June 2024 for further directions.
are in the same clothes. It's only today they are changing. As an officer of the force who visited, you have not been there. Thirdly, if you are not able to comply with the rules and orders issued by the court, you are able to keep quiet until they are sufficient. It should not be the case. It is our submission that it's not necessary in such a kind of situation we file our charges. The way they support it. And at this person can even stand here if they are here, if they are in court. To confirm the fact they are trying to do that. It is on that given context. We are kindly requesting that kindly allow all orders that they are consulting past the court be remanded in another police station. They can only support. They have wealth, they have staff, who they are visiting. They are failed to provide am the one who pursued it. If only the juniors cannot stand against their seniors and say what happened.
Station, since the conditions are deplorable, so the station, the court is aligned with the facts that under Article 27 states that every person is equal before the law, has the right to equal protection and equal benefits of the law. Therefore, the DCIO of the said police station hearing, that is Kayole and Roy, to ensure that the respondents access the basics, and if any of the respondents will require any medicine, the same will be available to them without any hindrance. Those are the orders of the court.